We can start, Anna. If you are ready, we can start.
Okay, I'm pretty ready.
Okay, so the stage is yours.
Okay, thank you very much. Good morning to everyone. My name is Jana Planjavová-Latanovic, and I come from the Warsaw University. And I will present today to you the issues related to intellectual property rights and their relationship with the data. First of all, let me present you reasons why I should bore you with law. And first reason why intellectual property rights and licensing that is connected with it is important for using data. First reason is that everyone is using words like cloud computing and big data, and but we don't know actually how it can relate to what we are actually doing, whether we can use it or not, whether everything what's on internet is available as free of charge and without any limits. So the second reason is connected with the fact that we are all using internet, and that in the internet, the experts say, the IT people say, that about 10% of what we see in the internet is that's actually what's on it. So that we just see 10% of the whole data that are stored on the internet. The third reason is that the data are ubiquitous. They can be found everywhere. So this is something what we see and find every day and everywhere. We make data in virtually all our activities we are doing on everyday basis. Actually, right now I'm making a lot of data because this is recorded, this session. So that's something is really practical, and we are not aware of the legal context connected with it. Then the fourth reason is that data generally, and especially big data, are very volatile. So they are not like physical things. They can move without virtually any restrictions. When I'm presenting this lecture, and this lecture is recorded, I actually don't know where it's going to be stored. I suppose that it might be stored on computers of the Charles University in Prague. But in case of a really big data systems like the Google search, and you can imagine how many searches is made by Google in this second, and all of them are making data. So you are not really aware when these data are stored, when they are present at this moment. So it can be in the United States, it can be somewhere in Canada, or this is just for us as customers. It's very it produces big amount of uncertainty what's happening with the information, with the data that we are producing. So then the issue for those who think about the data is who owns it? When we produce data, who is going the owner of it? Is it me, or is it somebody else? And is it the one on which the data are stored, or is it somebody else? So then the question is why we should care about it, why it is important, this issue. So whether using the data legally is important and when it is important. So, and the next issue is that if you think about or if you look into the law that is relevant for the data protection and use, you would see that it comes from the past. It may be 10 years, 20 years, and even 30 years, and even 200 years old. So if you look, for example, into the Berne Convention, and we will talk about it, that protects copyright, and copyright is used as a part, as a legal protection of databases. So, and it comes from the end of 19th century. So this is a very old legal rules. These are very old legal rules, and still they are relevant for what we have today. So in fact, the legal rules are not keeping pace and cannot keep pace with the new technologies. We have cloud computing. The cloud computing was not an issue when about 25 years ago, the European Union, then the European Community Database Directive was issued. So people never thought about it. So that's the next problem we are facing when we talk about legal protection of data. And the last thing is that when you think about when we use data, the word, then it is usually with some adjective, or it's a part of the word, like database. Then we protect databases. Then we protect the personal data. And people are very confused because the word data is something like a generic word, but there are some rules connected to that. So when we speak about the personal data protection, that's the situation in we have to give consent to use our personal data for the use of anybody else. So then we think about it, is it the data that we are talking about in this course? Yes, they are indeed. So what we first of all understand as data, and that's, I suppose that there might be a little difference between how the word data is used in the legal context and then how it's understood in the IT sector. And first of all, if we speak about the big data, it's not a legal term. This is rather used by IT people, and there is no strict definition in it. I always imagine big data as data so big that I can't even imagine how big they are. So it is something that really goes beyond our imagination. But the word data, as I said, is used by in various legal contexts, and usually it's a part of a word, or it's a adjective, with an adjective. So we have personal data, we have databases, and when we think about what the word data really means, then I would say it's in fact an information, because the data must contain an information. And that's how at least lawyers are dealing with understanding the problem. So the data, they bear some information. It may be the information who I am right now when I connected with the server of Zoom. So Zoom and the owner of the rights pretty know that I am now located in Warsaw and I speak from Warsaw right now. And that's an information. Then you have found the two words where the word data are quite part of it. And let's say data set and database. So what's the difference between a data set and database? As I said, the word database is a legal word. It's used in various contexts, but usually as a part of the intellectual property legislation. And the word dataset is used usually by IT people when they speak about the large some amount of data that are available. So what's the difference between this? The database, the word database means an amount of data, so it's a data set, and it is some way systemized. So it's either annotated, it has a certain structure inside. So we may say that every database is a data set, but not every data set must be a database. So the word data set is much more larger, and it may contain the raw data. They have no structure. So we use raw data, and we say we use data set. But at the same time, databases are having a data set inside. So that's why the word database is somehow more narrow than the word data set. Sometimes we use the word public data. So what mean by public data? Does it mean that what we see in internet are all public because it's available and may be seen virtually by everyone? Is it what we mean? No. As a public data, we understand the information in the public domain. So the data that are available, that are not subject to any intellectual property rights, and we will talk about it. So it should not be understood as something that remains unavailable to everyone. So internet data does not have to be open public data. Okay, so this is not the same. It doesn't have the same meaning. Then we use the word open data. So the open data is a sort of public data, because we will talk at the end what types of open data we have. And open data are public data, are structured and maintained. That might be, so someone who use the public data have made some progress, have made some work for it, and gives it under certain license. And that's why the licenses are important. So, for example, in the European Union, we have an open data portal, and all data here are considered to be available under the very loose and very liberal license attached to it. So we will talk about the licenses later. So, and then the last thing is about the personal data. So sometimes, and very frequently, we hear the word, we cannot use it because it's personal data. Personal data concept is very, I would say, fairly recent, because it means that for the reasons of protecting the privacy, the data of people are protected. So not everyone can use them. So not all data are personal data. Personal data are data attracted or data of the human beings. And you have a quite complicated legislation on the protection of personal data. And in the European context, it comes from the famous GDPR, so the General Personal Data Protection legislation. So issued by the European Union. So that's every time that when someone is using our personal data as name, date, when we were born, the personal number that we are having. So this is a sort of data that are protected by the law. In some countries, it is not this. So some countries are not protecting the personal data at all. So also the next issue that we will talk about is the question that this is limited. The protection of data is always limited to some jurisdiction. Okay, so the difference in protecting personal data is in between the European Union, where many of these issues is harmonized, and, for example, the United States, or the Asian jurisdictions in Asia, in China, in Japan, in Korea. These have differences in terms of conditions of use of not only the personal data, but generally the data in general as a part of intellectual property protection, rights protection. Okay, so then when we so you see this is very, very complicated, but in fact I will try to make it more simple, because there are some ideas that lay behind this. Okay, so like that for the protection of personal data, you have to think for why it is in place. It is in place to protect people's privacy. So when you deal with the type of data that somehow are connected with our right to privacy, then you may say it is probably the type of data that would be protected by the data protection legislation. So when you, for example, want to use the data concerning the health conditions, or when you try to use the data containing names and dates of birth of people, that would be the data protected by the personal data protection legislation. So in that case, you know that you have to ask the administrator of the data. So these data are not publicly available, so you have to go to the person that is designed to protect these data and ask for the permission of use. Usually these data are not publicly available. So when you want to make some use of it, you have to pass certain procedure in order to be allowed. This is the most strict, I would say, in Europe, is the most strict legislation on the personal data protection. Then when you are using data, there might be the question of what is safety and security concerns, because there might be data that can be misused in terms of safety and security. So these data also are not usually publicly available, and they are it is in the public interest to protect them and to store them in a way that does not allow for the open use. Okay? So in case, and that would be rather a situation quite exceptional, we want to use these data that may raise the safety and security concerns, then you have to ask the holder to lift the barrier that makes it inaccessible because of these concerns. So that's the second thing. And the third thing, and the most common, and that's probably the situation where we meet these limits of using the data are the economic concerns. So also in terms of economic concerns, there are the safety and security concerns, because not in the public interest, but for example, some data might be valuable for the company, and they are protected against being disseminated. The turnover of the company in the given year, how they are doing in economic terms, all these data that are viewed by the owner as being so important for the well-being of this entity, usually in the commercial context, that are protected. And the question of advertising. So some data are open in order to satisfy the economic concerns as a part of advertisement. So if, for example, even in case of what we call the open license, the open licenses are usually under the condition that you show the attribution. So if you use the data that were made available under the open license, then it means in virtually all situations that you know who made them, who put an effort into making them a structural, systematic data, so who have made the effort. So that would be a sort of improving the reputation of the original maker, and that's the, I would say, the least the requirement that virtually in case of every data under the open licenses exists. So this is the requirement that puts as a condition of use. In most cases, the use of data is limited because of profit. So these data are used as a mean to raise money, especially in the form of royalties. So this is the access to databases they are paid, or access to some servers to use the documents that are stored, or films, or that would be the reason, the economic concern in it, the profit. And then, last economic concern may be a limitation of competition. So you have to know that the intellectual property rights are one of the most effective means of protecting the commercial entity against outside competition. So let's think about the Microsoft products. They are protected against any change, against any improvement from the part of outside world. Because if it is done, then the derivative product might be better than the original. So then the intellectual property rights are used as a limitation of competition. So the ones who might have changed the product would be barred to do that, would be prevented to do that because of the intellectual property rights. And then, at last but not least, we have to see the reasons why we do have intellectual property rights. So I talked about the problems connected with it and why we just don't abandon the concept of intellectual property rights, why we don't say, well, everything is free of charge and everything is open, and that would help the mankind to to achieve better prosperity, because there would be no barriers, and in case only the personal data, there would be some protection of privacy, or in case of security. But in the economic terms, that would be, everything would be available for everyone. Why we don't do that? Because the profit is one of the incentives that is given to those who are inventive, those who are creative. So as a sort of payment for their creativity, that's why we have intellectual property rights. So the patents, the trademarks, the effort that has been put into some activity, that's the reason why we need to grant the creator certain exclusive rights. So the issue that we are dealing with in the case of intellectual property rights is any of them, not just the databases, computer programs. It's exclusive rights given of the owner, of the maker, to limit some, or to oversee the fate, what happens with the work, with the product, the database. So that's the reason why we have intellectual property rights. So you see that this is not a 0-1 situation, yes or no, but there are reasons for having the property rights protection, to have an incentive for those who are putting some effort into making something and inventing something. And they are, for this reason, given these exclusive rights that are protected by the legislation. And then, on the other hand, they may not be of such kind that they somehow limit the creativity of others. Okay, so that there has to be a fair balance in the creativity and the possibility to use and improve. So that's what the intellectual property legislation is about. So the data protection as a part of intellectual property legislation is usually in the public, in the economic interests of people. So in case of data protection, we see two types of protection. First of all, it is the copyright protection that is, as I said, very old legislation, some reaching the more than 130 years back. And it is applicable not only to the artistic works, and that was the original reason for making such kind of protection, that the artists would be protected. But quite recently, when the computer programs were made, then the authors thought how we are going to be protected. And the lawyers, well, they tend to use the old concept for the new situations. So they said, well, it is not necessary to make a special kind of protection for the computer programs, but we would use the copyright protection. So we would deal with the computer program the same way as we deal with the artistic work, like the movie or the book. So the same type of protection would be awarded to the computer programs, because the computer programs are in fact written. So that's the reason why copyright has been used also for computer programs. In case of databases, it's much more complicated. So the database that contains data as itself is protected by two types of rights. First of all, the database is protected by the, at least I'm talking about the European Union context. In the European Union, the databases are copyrighted. They do have copyright protection for the structure of the database, and sui generis, or sui generis, Latin word, its own right. It's a special right used only for database protection, sui generis right, that protects the content of the database, but not the content in terms of the movies itself, if it contains movies, or the books, if it contains books or articles or whatever. It is even the content that is not artistic or creative would be still protected by the database protection. So by the sui generis rights. This is based on what we call a sweat of brow doctrine. So the sweat of brow doctrine comes from the UK practice of court. So this is a sort of outcome of the English decision making. Court cases, they make law, and the sweat of brow doctrine is based on very practical thinking, that even if the outcome, the data set, is not creative as such, does not have any element creative element inside. For example, the case of the telephone directory. Telephone directory doesn't have a creative content. It has a amount of data in it, and it's not creative. Especially the creativity cannot be seen in a structure. It's usually in a alphabetical order, and that's it. So you cannot see it is a very creative thing. But at the times where the telephone directories were in a printed form, so the old directories, it was put a very much effort into making them, because you have in pre-computer, pre-internet times, you have to assemble a huge amount of information. And so the outcome was not very artistic or creative, but it was very difficult. It was very time-consuming, work-consuming, money-consuming to make all this work. So, and that's why the English court says, because it's so difficult to put these data in, then we would grant a protection to the content. And that's the basis of what we have now, the sui generis right in the European Union. So sui generis right of the protection in case of databases. So the databases are protected, as I said, there is a two-tier protection. First is a copyright protection. So the databases are copyright on the basis of copyright protection. That's the first level. And the second level is the sui generis right. So let's say a few words about the copyright protection. The copyright protection, as I said, extends to artistic, literary works. That was the original meaning. But then it was enlarged also to the non-artistic other works, like the computer programs. And the computer programs are, in fact, covered by protection the same way as the original collection of literary or artistic works. So in the international legal framework, we have several conventions and several treaties that are directly relevant to the collection of data collection information, either in a classical form or, and this is more recent, in the electronic form. And you would see that these more recent agreements, like the TRIPS agreement, so TRIPS means or stands for trade related issues of international property protection. So this provides for copyrights. TRIPS has been TRIPS agreement has been concluded as a part of the WTO, and it provides for copyright protection also in case of compilation of data and other materials, trade-related issues of international property, intellectual property protection. So what we have, that's the basic regulation on the international level. And then we have a part of the old Berne Convention that I have already mentioned. And then we have what we call a WIPO copyright treaty, WIPO being a international organization for the World International Organization for the Intellectual Property protection, and it does contain concluded multilateral treaty, what we call copyright treaty. So this copyright treaty protects compilation of data in any form. So it's important that we speak about any form, which is which covers also the protection of the data in classical physical form, but also in electronic form. And it is important that the WIPO copyright treaty states that it's the reason for giving protection to compilations. It's by reason of the selection or arrangement of the content. So that if you have a selection or arrangement of the content with some amount of creativity, then you are awarded the protection. So the WIPO in the international context, unlike the European legislation, does not understand that the content made can be such a can be protected itself. So the international protection protects only what is protected in the European Union by the copyright, which is in it. So, so the EU Database Directive that we talk about, in fact, increased very much the scope of legal protection of the database makers compared to what we have on the international level. Because it adds the second tier of protection in the form of sui generis right. So it had a tremendous impact on the database industry in the European Union because the data had been more protected, then it would be possible to generate more profit. That's why it started a blossom of the database industry in the European Union. So the reason for this development is the double scheme of protection, so the copyright plus generic rights in the for the database protection. There is one, I would say, important note. When we speak about the protection of databases, we don't speak about the just about the content, and nor about the computer program that might be used for using the database. So the database would be also protected if you need a computer program for accessing it. And this computer program is has a separate protection from the protection of the actual database. So if you need a program, the program would have a protection as a computer program, part of having the database being protected by copyright and pseudonymous rights. And the third, the content of the database. Also, if, for example, contains artistic work, then these pieces of artistic work, film, music, whatever, would be protected as pieces in itself. So you see that this is the intellectual property protection legislation really makes a huge bulk of protection in order to somehow favorize those who are creative, that every piece of human's creativity is protectable. Okay, so when we speak about the database protection, so in the Database Directive, we do have a definition of database. So what's a database in terms of law? So it is a collection of independent works. So these independent works, as I said, may be protected in itself. So each work can be protected on the basis of copyright, we should say scientific work, artistic work, etc. But also the database may be composed of other materials, so not materials that are subject to copyright in itself. So it may be the telephone directory. And but what is the subject of protection is not what it contains, but how these materials are arranged in a systematic or methodical work. And it's irrespectively whether it is accessible by electronic or other means. So this is how we understand the protection of databases, because of systematic and methodical arrangement. That's why it is protected. So we also have to see, and that is very important, that any type of protection in these internationally accepted standards are very jurisdiction specific. So the European Union has made a legislation that aims to harmonize the intellectual property legislation in Europe, because the differences in terms of protection, so in conditions of protection, make a very important barrier in terms of internal trade in the European Union. As I said, the intellectual property rights also limit competition. So the intellectual property rights can be used for limiting the competition from the outside of the one country with respect to other countries of the entities from the other country of the European Union. And that's why the European Union made a certain common standard of protection that is applicable for all member states of the European Union. That's why we have the directive on protection of databases. But we have to see that this common standard does not protect everything, doesn't say everything about the content of the protection. So each member state of the European Union has its own copyright legislation that must be in accordance with the European legislation. But it can, within the sort of possibility to depart from the standards. So they may somehow make changes to it when it is allowed by the legislation. And when the EU legislation remains silent, they can make its own rules. So that's what I want to say, that the legislation concerning intellectual property law may vary from country to country. So it is harmonized in the European Union, but still there might be differences in terms of some conditions of protection. So the European legislation has a limited scope. That's what I want to say. So it is applicable only to persons who are nationals or habitual residents of the EU state. So this is not a worldwide legislation, but this quite a high level of protection is afforded only to those who are nationals or habitual residents of the EU state. So in case of companies, because the protection also covers the companies, the subject protection of the right holders, maybe the companies with the principal place of business or central administration within EU are these rules applicable. So as an end users, so as a users of this, we see the problem that when we are dealing with the cloud form of, for example, computer programs or cloud databases, then we really are uncertain where the owner of the database or the right holder has the principal place of business, central administration. So sometimes for us as end users, it leaves uncertainty what type of protection is available. So as I said, in case of databases, we have double level of protection in the European Union. On one side, we have copyright, and the European legislation also introduced a new sui generis right in case of databases. So the copyright in case of databases covers the selection or arrangement of the content. So the intellectual creation in terms of how the content has been selected, arranged, and that's what's protected by copyright. And then you have the second level of protection, and this is the sui generis right that has to give some protection for substantial investment that was made by the maker of the database. So that's the issue of the database protection in the European Union. So the reasons why the European Union decided for such rules, very strict rules concerning the wide protection of the databases, is to first of all, prevent free riding. So the databases, they are protected against unauthorized use. First of all, it is not important whether the database is publicly available or not. Okay, so it doesn't have anything in common. So even the database that is publicly available without free of charge without any payment, without any restrictions. Use still is a subject of intellectual property legislation, so it is a subject of protection. So you cannot use the database without the permit of the environment. So first reason that was to prevent free riding. The second reason was what I have already mentioned, that there is a high degree of variability of the terms of protection among the member states that have the negative impact on the internal market. So the differences in jurisdiction always make a content a substantial barrier in terms of trade. So they decided in the European Union to make a common standard of protection. It doesn't concern only databases. It concerns also the copyright and related rights. It concerns derivative works. So there is a plenty of intellectual property protection legislation in the European Union. And the reasons are virtually, for making it, are virtually the same. So the what is important in terms of using the data from the database is when I can use, if I am the lawful user of the database, when I can use it for what we call a text and data mining. So do I need to request a permission, or how it works in practice? So all these exceptions and limitations of for right for text and data are available under one presumption, that the access to the database is lawful. So you may not hack or enter the database in an unlawful way. So if the database is given free of charge everyone, then you have no barrier in case of the payment. You have to make payment in order to have more access, or any other. If you have personal database, personal data, then you have to ask the administrator to use the content. So under these conditions, where the text and data mining is meant as any automated analytical technique at analyzing text and that data in digital form in order to generate information which includes but is not limited to patterns, trends, and correlation. So that's how the European law understands text and defines, in fact, texts and data mining. And you can freely use the data in case of, and this is the important thing for scientific research. So scientific research is one of the most frequent limitations. So the idea is that the scientific research makes people's, I would say, advancement is a condition for advancement of mankind, and that's why there is this sort of exemption that is available to scientific research. The scientific research, for the purpose of scientific research, it is allowed to store the data. So, for example, if the I'm a migrant stories, and you will work with it with my colleague from the Faculty of Social Sciences, are used for the data for the research, then it can be stored, though the texts itself are probably covered by copyright. So the scientific research is one of the possibilities to use the data for the text data and other types of data as a for the purpose of data mining. In case of reproductions and extractions of lawfully accessible works. So lawfully, in terms also means when it is available on the internet. So then it can be used in general outside of the outside of the scientific research. Also can be used for data mining. Including the temporal attention. So temporarily the data can be retained unless it has been expressly reserved by the right holder. So right holder may limit the text and data mining in other than scientific research. So that's important for what we are doing at the university and during this course, that we do have a right to use and the texts, the images, for the purpose of research. And even in case of publicly available data, the data mining can take place unless the holder says no. The right holder says no. So there is a special, for the purpose of teaching activities, there is a special provision to this end. The digital and cross-border teaching activities like we have right now, the use for the sole teaching activities is only possible if it has to achieve non-commercial purpose. So in case of when we would like to solve this, for example, these lectures, that would not be non-commercial purpose. So any data mining or any text mining, if we would do it with the intention to sell it, that would require the permission of the right owner and maybe and be compensated. So also in case of teaching activities, even for non-commercial purpose, the right holder may require fair compensation. So this is the example of computer programs that may be used by schools and other educational establishments if for non-commercial purpose. Then usually the holder is given a free license to use these programs. So I am using now, or I started to use the word a license. So what we do understand by saying license, and when we do one. So in fact, by saying the license, I mean a sort of agreement. So it's sort of, you want to use in a contract. And the contract implies that it's writing, so it doesn't have to be in writing. So it's just the agreement that we both parties agree of two parts, the intellectual property rights holder, and that's the licensor, and by agrees or gives right to another person, the licensee. And the conditions of license may vary, and we will talk just about it in a few seconds. So maybe it's obvious, and I shouldn't mention it, but intellectual property rights maybe have commercial value. So they may be sold. Rather in law, we use the word maybe transferred or assigned to somebody else. That's how we always express that we are in fact selling it. But the licenses doesn't have to just be just the selling of the license. They may give some part of right. So I return the right to decide about the distribution of the computer program, about the changes of the computer program, but I give an individual license to the people who use it. So this is a license for the use, but not for the changes of the database. So you see that this is a sort of limitation that stems from the exclusive right of the holder. That's why we have the intellectual property rights, that the intellectual property rights has right to decide about the rights that it gives away and what sort of rights it gives away. So that's a conditions of license. Under what condition? Okay, so in practice, what does it mean? So before we use any data, we have, and this is the first thing, is it a personal data? Because if it's a personal data, then we have to use it as an egg, okay? We cannot use it just as we have it, but we have to prove that we have right to access the data. Okay, so in this situation, we have to ask data administrator, personal data administrator. So for that purpose, each company has to have someone who is responsible for protection of the personal data. So before we use this data, we have to ask the data administrator to give us a permission for this data. Because if we don't ask for the permission, we are even in a worse situation when we breach intellectual property. This is not intellectual property, what we are talking about. Personal data, it's a public concern, and there are the penalties that may be imposed in case of breaching personal data protection. Not only on the part of the subject who have to protect it, but also on the part of subjects who might use it. So it's very, very dangerous not to have or use personal data without having a proper consent to do that. When we speak about the other types of data, first thing we have to ask whether the data using are protected by the intellectual property rights, because not all data, and if yes, in what way? Okay. Because there are some sort of data that are not covered by the legislation, so they are not afforded intellectual property rights. For example, in the case of copyright. The copyright protection is not usual. That's Europe, but also in the United States, is not afforded to the documents of the government, of the official documents of the state administration. It is not the law itself. So the legislation, either state or European Union legislation, is not subject to copyright. So that's where we can use, okay, without asking anyone or asking permission or look for the license. Okay. In other cases, we have to think about whether we do have a right to use it, whether there was a license issue. And that's why we will talk about the open licenses and the non-open proprietary licenses. So If we do have a license, either because it is not subject to intellectual property rights, or it was waived the right, for example, to decide about the use, like in the case of open licenses, then we have to be aware that the copyright protection lasts for 70 years from the day the author died. So in case of, for example, André Mazon collection, we have to look at the content of the collection. So whether it contains some, let's say, scientific, literary pieces, because I know that André Mazon correspondence might vary very much the content of it. There might be just brief letters or postcards to his friends, but also there might be a scientific essay or the piece of poetry in it. Okay, and in such a case, the content, this content may be subject to copyright if it took less than 70 years from André Mazon's death. So that's the protection for using. The problem we have here, in case of André Mazon's, that the original protection is connected with the original physical letters, the postcards, and so on. In case of turning it into digital form, and that's what the Sorbonne University has done, so that would mean that it is a part of the larger collection in a digital form, so that would be part of the database. And this André Mazon collection has a part of the protected by copyright. That's the question, how it is organized as a database, and that's what we spoke about, the two levels. And then the second level would be for all the effort, investment, time that has been put into making it and turning it into digital form. So that's the reason we can use the André Mazon collection for this course, is thanks to the permission that was given by the Sorbonne University to use it within this course. So this is a practical use of the code and the sui generis right. So in case of computer programs, so if a computer program is needed to enter the database, then it is, as I said, separately protected, and the protection is the same. Okay, so the terms of protection are the same as copyright. So that means that it also is protected from 70 years from author's death. So you can see that in case of programs, computer programs, sounds silly because no computer programs can survive such a long time, and it is provided that they remain unchanged, because as soon as you introduce some changes either into the database or into the computer program, then the time of protection starts anew. So this is a very important question. So what types of licenses we do have for software and data? First of all, we speak about the open license. You can hear it all the time long. And what we mean by having the open license. Open license means a situation when the right holder, intellectual property right holder, gives right to use of original work to anyone, provided, usually at no cost, provided that the user follows certain conditions of license. And that the conditions of license may be quite variable. I will show you it later on the example of the Creative Commons license. The open license usually, but not always, allows for building up on the original work, changing the original work, improvement or customization. So it is also the case of computer programs, but also of the artistic works. So you can make a mixture of the music. You can use it, translate, for example, the in case without any restriction, if such a permission was given. The example of the place where you can find open license original work are Creative Commons. Creative Commons, they contain written works, images, music, visual, and other artistic expressions. If you want to use for extraction, and the analysis by mechanical means, by computer program, the written works, images from the Creative Commons, then you don't have to be afraid of breaching any law. In case of software, one of the places where you can find software that is with open license is GNU General Public License. There are several places where you can find, this is just the two examples for two places, different content. Well, some intellectual property rights in case of open licenses are waived, and you also have to check what exactly was waived, because in case of open licenses, the works original, as far as the intellectual property rights are waived, start to be in what we call a public domain. So the word of public domain relates to the question of open license. So the open licenses made the work in a public domain, and I will explain it in a minute. The second type of licenses are proprietary licenses. So this is the situation when the intellectual property holder didn't give away its rights and retains control over the work, computer program, or a database, and usually does not allow for any changes, improvements, customization, etc. So in case of proprietary licenses, whenever you use for example, database and you pay off it, usually it's on commercial basis, you have to pay, and it's limited to the right of use. So for paying, you get the right to use it. So you can copy it, you cannot change the database, you just can't use it. So this is usually the content, the proprietary licenses. But I mentioned here something what's called a public domain. So what's a public domain concept? First of all, this is not a legal term. So this is what generally is understood when we speak about public domain concept. And it usually refers to a creative works that can be the literature, images, the texts, or even the computer programs to which no exclusive intellectual property rights apply. And they might not apply from several reasons. First of all, because they have not existed. So, for example, the Bible is not subject to any copyright, or the law does not afford the protection, like in case of the legislation. State legislation is usually not covered by copyright. It had expired, like the Shakespeare works. Just 70 years from the death of the author, it has expired at the end of the protection. All been forfeited, so they have not been used. Yes, they have not been used, the rights. So, or they have been expressly waived. Expressly waived means, in terms of open license, that they say this is open license. So under these conditions, you are free to use the data, the work, the whatever you have under this license, or the computer program. So that's a public domain concept. So public domain is not whatever you have in the internet. So because in the internet, some are in public domain, some texts or images. So it's the public domain. What's in a public domain is different from country to country and from jurisdiction to jurisdiction. So it's different in each country. So different rights, different might be the regulation in France and in Czech Republic and in Poland. We do in Europe have this common harmonizing standard from the European Union, but in details it can vary. Just as a matter of example, I wanted to show the Creative Commons public domain mark. So how you may, the Creative Commons shows that the copyright is not applicable for whatever reason. So that's the picture you can see. Okay, and now last but not least, the examples of Creative Commons licenses. There are 6 different Creative Commons licenses. And you see that they are a mixture of certain letters, and usually the most loose, the most open license requires only the attribution. You have to say who is an author and just claim that this is the original work made by this person that you are using. Okay. In case of other types of licenses, you might be required to use the same type of license to your outcome. That's the license share alike. That requires that you have to, if you improve, change, you have to share it in the same way as you got it. Okay. That's the share alike license. License with no derivatives. That's the situation I mentioned before, that in case of some Creative Commons licenses, you might be asked not to use it, to mix it, to create a new work out of the old one. Okay, so they are. This sort of work is more protected because no derivatives can be made out of the original work. And a last type of license is that one that requires for non-commercial use. So you can use it, but not commercially. So there is a further limit. So you can see that there are some, there is a sort of structure of basically 6 licenses, 6 types of licenses that have different conditions you have to fulfill in order to use the work in question. And last but not least, if you ask whether the data as such are under the common public domain dedication and license, yes, they are. And that's the place where you can access the data and databases that are under the open license. Okay. And that's the end of my presentation. So if you have any question, it's probably right time to do it. And I'm free to answer them if I know